Hello, good morning everyone. Good morning everyone. Today we shall be discussing about the case of Attorney General of India versus Satish and another. So how many of you have joined so far? 6 people. Okay. Good morning बात जज्बात हो तुम. Good morning Midhat. So this is a very famous case, a landmark judgment, and which has popped up from a very controversial judgment of the Bombay High Court. Because in State versus Sateesh, the original case, when this person named Satish, the accused in this case, he enters the around 10 to 12 years of aged girl. She happened to be her neighbor. When she was sent out by her mother to fetch guavas, and when she did not return for a very long time, her mother started searching her. Okay, her mother started searching her, and someone told her that she was taken away by one named Satish in his house. When she went to that house in her neighborhood, and when she heard heard her daughter screaming from in a very bad situation, she was frightened, she was scared, and her salwar was also removed. Now this case was held to be he was tried under the POCSO Act, the Prevention of Children from Sexual Offences Act. Okay, yes Bajatum, we did another case of the Bombay High Court, but this is the judgment of the Supreme Court. The Supreme Court has now what the Supreme Court has held while setting aside the judgment of the Bombay High Court was not dealt by us. Okay, that is why I am taking this up, that we did discuss about the judgment of the Bombay High Court, but we did not discuss about how the Supreme Court set aside the judgment of the Bombay High Court and what Supreme Court has said in this case. Okay, now in its judgment, Attorney General for India versus Satish and another, the judgment of the Bombay High Court was set aside by the Supreme Court, because when the matter went before the Bombay High Court, to the surprise of many of us, it was a case which was beyond any intellectual understanding, because a single lady judge of the Bombay High Court held that sexual harassment has not been constituted under the Prevention of Children from Sexual Offences Act. Okay, POCSO. And POCSO is something that needs invocation at a time or in a situation where there is only skin to skin contact. That means in order to constitute the offense of or complete the offense of sexual harassment, there should be skin to skin contact between the perpetrator and the victim. Mere removing of salwar or touching the girl or a child from over and above the cloths, okay, does not constitute sexual harassment. Now, this kind of uncomfortable touching or these kinds of unwelcome behaviors are not covered under the POCSO. Okay, now in its judgment, when the matter went before the Supreme Court literally reprimanded the Bombay High Courts for its observations, for its ridiculing observation. Okay, and hence this case, Attorney General for India versus Satish and another. Understood? Understood, all of you? Now, in its judgment, Attorney General for India versus Satish and another, 2021, the Honorable Supreme Court set aside the judgment of Bombay High Court, which held that skin-to-skin contact is a prerequisite for an offence of sexual assault to be made out under the Protection of Children from Sexual Offences Act 2012. The case arose out of appeals filed by the Attorney General of India, the National Commission for Women, and the State of Maharashtra against two judgments of the Bombay High Court, both authored by Justice Ganediwala. In this article, the author will highlight the facts, submissions made, and the judgment given by the Supreme Court in this case. Now, what is the background filing of appeals in this case? 4 appeals were filed before the Supreme Court by the appellants. Who were the appellants? Attorney General of India, National Commission for Women, State of Maharashtra. An appellant accused Satish against the judgment dated 19th January 2021 passed by Bombay High Court, Satish versus the State of Maharashtra, holding that skin-to-skin contact is necessary to constitute an offence of sexual assault under Section 7 of the POCSO Act. Now the question is that Satish was convicted under various other provisions of the IPC for enticing the victim and taking her away, and doing these kinds of things. He was convicted under various other provisions of the IPC, but he was exonerated and acquitted under, like, all his charges under the POCSO Act 2012. They were dropped only because there was no skin-to-skin contact. So the question is that, are we waiting for the skin-to-skin contact to happen to invoke the provisions of POCSO 2012? That is the question. That's how ridiculing it was. So another appeal was filed by the State of Maharashtra against the judgment of the same bench dated 15 January 2021, Libnus versus the State of Maharashtra, wherein it was held that acts of holding the hands of the minor girl or opening the zip of pant do not constitute sexual assault under the POCSO Act. The Honorable Supreme Court heard and disposed of all the appeals together. So that means another appeal, which was also filed by the State of Maharashtra against the judgment of the same bench, was in the case of Libnus versus the State of Maharashtra. Libnus versus the State of Maharashtra में Bombay High Court ने ये कहा था, wherein it was held that acts of holding the hands of the minor girl or opening the zip of pant do not constitute sexual assault under the POCSO Act. The Honorable Supreme Court heard and disposed of all the appeals together. Okay, now Satish versus the State of Maharashtra. The victim, aged about 12 years, had gone out to obtain guava when the accused, a man residing in the neighborhood, took her to his house under the pretext of giving her guava, and then pressed her breast and tried to remove her salwar. When the victim shouted, the accused pressed her mouth. The informant in the case was the mother of the victim, who lodged a complaint against the accused. The special court convicted and sentenced the accused Satish for the offences under sections 342, that means wrongful confinement, section 354, okay, outraging the modesty, and section 363, that means kidnapping from lawful guardianship of Indian Penal Code, and section 8 of the Protection of Children from Sexual Offences Act 2012. Okay, now have you understood up till here what we have discussed so far? Do not confuse between the two cases of Satish versus the state of Maharashtra and the Libnus versus the state of Maharashtra. Please don't confuse and don't mix the two. However, the appeals were filed together and they were all clubbed together because they happened to be against the single bench of the, and they all were pertain to the same nature. Okay. Now you must have got the idea about it, that what is the question to be mooted upon by the Supreme Court. You must have got this idea, isn't it? Isn't it? Okay. Now, the accused filed an appeal against the said order and judgment in the Bombay High Court. In appeal, the High Court acquitted the accused under Section 8 of the POCSO Act and convicted him for a minor offence under Sections 342 and 354 of the IPC. Justice Ganediwala of Bombay High Court made the following observations in her judgment. The act of pressing of breast of the child aged 12 years in the absence of any specific details as to whether the top was removed or whether he inserted his hand inside top and pressed her breast would not fall in the definition of sexual assault. Okay. Now the accused filed an appeal against the said order and judgment in the Bombay High Court because what the Bombay High Court said was that in Libnus versus the state that in Satish versus the state of Maharashtra, the act of pressing of breast of the child under aged 12 years in the absence of any specific details as to whether the top was removed or whether he inserted his hand inside the top and pressed her breast would not fall in the definition of sexual assault. Can you imagine? Do you find this observation acceptable? My question is to you. How do you want to comment on the observation of the Bombay High Court in the two judgments? How do you want to comment on the observation of the Bombay High Court in the two judgments? My question is to you. I am asking you, how would you have behaved this way? How would you have behaved after listening to such judgments in an open court? Yes, exactly, Prablin. It shakes the faith of people over the courts. There was a wrong interpretation of the provisions of the act, isn't it? How can you, if someone is even trying to press the breast or is trying to, touch the vagina or these kinds of doing these kinds of things from over and above the clothes, then don't you think that it amounts to sexual assault? This is absolutely disgusting. This is vile, vilifying. This is, I don't have words how condemnable it is. Can anything be more disgusting than this? That we are waiting for the skin to skin contact to constitute this offense of sexual assault, and we are not considering from what was happened in the two cases. Okay, now in Leibniz, Prablin says, if the guardians of justice are giving these kinds of judgments, then criminals like these are given liberty to do offenses. Yes, it gives them impunity to do whatever they want to do. In Leibniz versus the State of Maharashtra, in this case, the accused was charged with the offense of aggravated sexual assault. What is an aggravated sexual assault? When these sexual assaults or sexual harassments, they are committed by people of public nature. That means like the police officers. Okay, that means if these are done by the guardians of the people, like the police officers, okay, from by any public servant, when the sexual assaults are committed by any public servant, they are known as aggravated sexual assault. So accused was charged with the offense of aggravated sexual assault. The victim was a girl aged 5 years and her mother was the informant in the case. When the mother and father of the victim were not at home, the accused Leibniz came to their house asking for the father of the victim. On finding out that both parents of the child were out, he held the hands of the victim, lowered her pants, and thereafter unzipped his pants and showed his penis to her, and then asked her to lay down on the wooden cot. See what happened in this case. The victim was a girl aged 5 years and her mother was the informant in this case. When the mother and the father of the victim were not at home, the accused Leibniz came to their house asking for the father of the victim. On finding out that both parents of the child were out, he held the hands of the victim, lowered her pants, and thereafter unzipped his pants and showed his penis to her, and then asked her to lay down on the wooden cot. A complaint was lodged against the accused for offences under section 354A 11 and 448 of the IPC and sections 8, 10 and 12 read with section 9M and section 11(1) of the POCSO Act. The special court convicted and sentenced the accused Leibniz for offences punishable under section 448 and section 354A11 of IPC and sections 8 and 10 read with sections 9M and 12 of the POCSO Act. Aggrieved by the said order and judgment, the accused filed an appeal before the Bombay High Court. Now the Bombay High Court had to deal with these kinds of cases of similar nature. Okay, POCSO Act. The High Court in the appeal filed by the accused Leibniz set aside the conviction for the offences under sections 8 and 10 of the POCSO Act and upheld the conviction for the offences under sections 448 and 354A11 of IPC read with section 12 of the POCSO Act. While interpreting section 7 of the POCSO Act, the High Court relied on the principle of ejusdem generis to hold that the expression any other act in the definition of sexual assault under section 7 of the Act encompasses within itself the nature of the acts which are similar to acts which have been specifically mentioned. The acts of holding the hands of the prosecutrix or opening the zip of the pant, not being of the same nature or closure, do not fit in the definition of sexual assault. See, the Bombay High Court, this Justice Ganediwala, he was trying to, save the accused in every case. That this does not amount to sexual assault if he's simply unzipping the pant, if he's simply holding the hands of the prosecutrix, they do not amount to sexual assault. See, look at, he was ready to convict the accused in both the cases, like in Leibniz versus the State of Maharashtra and in Satish versus the State of Maharashtra also. He was ready, he was willing to, and he actually did that he convicted the accused under various other provisions like 354 and 448 of the IPC, 342 of the IPC, 363 of the IPC, but he was not willing to convict them under the POCSO, because he said that so far as the interpretation of sexual assault is concerned, merely unzipping the pant or holding the hands of the prosecutrix do not amount to the sexual assault. For that, there should be a skin-to-skin contact. Okay. Nishi Tripathi says that disbelief, any prudent person would understand that it is clearly wrong? Absolutely, absolutely. Now, in submissions on the behalf of the appellants, following submissions were made on behalf of the appellants. 1. The interpretation of the provisions of the POCSO Act as done by the Bombay High Court would have a devastating effect on society at large. Obviously, Attorney General of India, the National Commission for Women, they were trying to, convince the court, convince the Supreme Court that whatever interpretation was attributed to the provisions of the POCSO Act 2012, they are going to have a devastating effect on society at large, because people would then get impunity to do this, to do this from without making a skin to skin contact. And yet again, all the alleged acts of the accused, including taking the victim to his house, removing salwar, pressing breast and mouth, were acts amounting to sexual assault within the meaning of Section 7, punishable with Section 8 of the POCSO Act. And this was what the appellants were trying to do. They were trying to convince the Supreme Court on this point, that taking the victim to his house, removing salwar, pressing her breast and mouth, they were all amounted to sexual assaults within the meaning of Section 7, punishable with Section 8 of the POCSO Act. Okay, then the interpretation of the word physical contact as meaning skin to skin contact is a narrow interpretation that defeats the very purpose and object of the POCSO Act. Now, the appellants were trying to establish that physical contact, when we are talking about physical contact does not merely mean skin to skin contact. It may be from over and above the cloths. It may be done, physical contact may be done from over the clothes. So, you don't need to remove the clothes for making an actual physical contact. Okay, skin to skin contact is a narrow interpretation that defeats the very purpose and object of the POCSO Act. There was no scope for application of the principle of adjustum generis, and it should not be applied where it would defeat the very object of the statute. There was no scope for application of the principle of adjustum generis, and it should not be applied where it would defeat the very object of the statute. Section 7 includes two parts. First is an act of touching with sexual intent the vagina, and second pertains to any other act with sexual intent which involves physical contact without penetration. Now, Section 7, they were relying heavily on the words used or contained under Section 7. The appellants were trying to say that what is the phrase used under Section 7? That is touching with sexual intent the vagina. And second part says any other act with sexual intent which involves physical contact without penetration. Thus, it is clear that mens rea, the sexual intent of a person, is the most important and material thing in case of offense of sexual assault. The words touch and physical contact in Section 7 have been used interchangeably by the legislature. Okay, the words touch and physical contact can be used interchangeably. Interchangeably can be used, touch and physical contact. There is hardly any difference between touch and physical contact. Touch is like if you are touching somebody from over the clothes, then it's all right. This amounts to physical contact. You can also call it a physical contact because these are the terms which have been used interchangeably by the legislature. Now, in terms of Section 29 and 30 of the POCSO Act, the court is required to presume the sexual intent on the part of the accused, and it is for him to prove that he had no such intent or culpable mental state. Okay. In terms of Section 29, yes, the word child is here gender neutral. It may be anyone, a girl or a boy. Okay? It's gender neutral. In terms of Section 29 and 30 of the POCSO Act, the court is required to presume the sexual intent on the part of the accused, and it is for him to prove that he had no such intent or culpable mental state. Okay? Now, submissions on behalf of the accused. What the accused was trying to say? while relying on the case of Bandhu Vittal Rao Borwar versus the State of Maharashtra 2016. The learned senior advocate appearing for the accused submitted that the expression sexual intent cannot be confined to any predetermined format or structure. And as the POCSO Act defines the term sexual assault, the definitions of words assault or criminal force as given under IPC cannot be imported into the POCSO Act. Okay. The learned senior advocate appearing for the accused submitted that the expression sexual intent cannot be confined to any predetermined format or structure, and as the POCSO Act defines the term sexual assault, the definitions of words assault or criminal force as given under IPC cannot be imported into the POCSO Act. The first part of section 7, that is the act of touching of private parts of the child, may not require skin to skin contact, but the second part, that is the other act with sexual intent, which involves physical contact without penetration, requires a skin to skin contact, which is to be proved by the prosecution. Now, what they were trying to rebut every argument by the appellants. Whatever the appellants were trying to put across, they were trying to rebut them each point categorically, one by one. The presumptions under section 29 and 30 make it difficult for an accused to prove his innocence, and so any interpretation other than the strict interpretation would expand the offence, which would go against the constitutional objective of Article 21. So he says that if you are attributing such wide interpretations without any proper reasoning, then this would amount to, this will defeat the features of the Article 21. This is going to defeat Article 21, the right contained under Article 21. The advocate for the accused invoked the rule of lenity, which requires the court to resolve an ambiguity in a criminal statute in favor of the accused by doing a strict or narrow interpretation. Now there is something called rule of lenity. Rule of lenity means leniency. Okay. Leniency means that if there is any ambiguity in case of in any criminal statute text, if the advocate for the accused invoked the rule of lenity, which requires the court to resolve an ambiguity in a criminal statute in favor of the accused by doing a strict or narrow interpretation, then that means rule of lenity is that if there is any ambiguity, if there is any doubt in a criminal statute, it should be given in favor of the accused by giving it a narrow interpretation. It should not be interpreted in its widest terms. Lastly, there are a lot of contradictions in the oral evidence of informants, and it would be risky to convict the accused on such sketchy evidence. There are a lot of contradictions in the oral evidence of informants, and it would be risky to convict the accused on such sketchy evidence. Now, important legal provisions of POCSO Act. The Protection of Children from Sexual Offence Act 2012 has been enacted to protect children from the offence of sexual assault, sexual harassment and pornography. Section 7 defines sexual assault as touching of the private parts, vagina, penis, anus or breast of the child with sexual intent, or making the child touch a person's private parts, or doing any other act with sexual intent which involves physical contact without penetration. Okay. Section 7 defines sexual assault as touching of the private parts of the child with sexual intent, or making the child touch a person's private parts, or doing any other act with sexual intent which involves physical contact without penetration. What is Section 8? Section 8 provides punishment for sexual assault, that is simple or rigorous imprisonment which shall not be less than 3 years but which may extend to 5 years, and fine. We have nothing to discuss on the quantum of punishment. It's a part of the substantive law. So there is no jurisprudence as such involved in the quantum of punishment. These quantum of punishments are, they are also decided on the basis of jurisprudence only. I'm not saying that it has nothing to do with jurisprudence, but we don't need to discuss them right now. Section 9 enumerates the cases where sexual assault is said to be aggravated sexual assault. For instance, clause M of section 9 provides that whoever commits sexual assault on a child below 12 years is said to commit aggravated sexual assault. Okay? Section 9 enumerates the cases where sexual assault is said to be aggravated sexual assault. For instance, clause M of section 9 provides that whoever commits sexual assault on a child below 12 years is said to commit aggravated sexual assault. Okay? Now, if these, sexual assault is committed on a child when he or she is below 12 years, then that sexual assault becomes aggravated sexual assault. Then section 10, it provides for punishment for aggravated sexual assault, that is imprisonment of either description for a term which shall not be less than 5 years but which may extend to 7 years, and fine. Now the main issue in this case relates to the interpretation of section 7 of the POCSO Act. Analysis by the Supreme Court. The court observed, now before we discuss about the analysis of the Supreme Court, have you understood what we have discussed so far? If you have any question, please do ask. Now before we discuss about the analysis of the Supreme Court, have you understood? Understood? Okay. No questions? Baat Jazbaat Tum has understood. Nikhil has understood. No questions? Okay. Now analysis by the Supreme Court. The court observed that while interpreting a statute, such a construction has to be adopted. Such a construction has to be adopted. Which promotes the object of the legislation and prevents its possible abuse. Okay? The court observed that while interpreting a statute, such a construction has to be adopted which promotes the object of the legislation and prevents its possible abuse. The court also observed that the POCSO Act was enacted to prevent children from sexual assault, sexual harassment and pornography. The Supreme Court said that we have to keep this in mind while in giving any interpretation to any clause or any text of the statute, that what is the object of the legislation, what the legislation was trying to do by enacting this clause or this law. The court in this case also observed that the POCSO Act was enacted to prevent children from sexual assault, sexual harassment and pornography. Okay, so we cannot attribute any narrow interpretation to any clause or to any phrase under section 7. We will give them the widest attributions, widest interpretations, okay, which promotes the object of the legislation and prevents its possible abuse. After analyzing the dictionary meaning of the words touch and physical contact, the court expressed its agreement with the submission of appellants that both words have been used interchangeably in section 7 by the legislature. After analyzing the dictionary meaning of the words touch and physical contact, the court expressed its agreement with the submission of the appellants that both words have been used interchangeably in section 7 by the legislature. Appellants, we have already read the submissions by the appellants. The appellants were trying to prove this, that touch and physical contact are hardly different from each other and they bear similar interpretations. So the question is that what the Supreme Court was trying to find out. The Supreme Court consulted the dictionary and they said that whatever has been submitted by the appellants with regard to the interpretations and the meanings of the word touch and physical contact, they're absolutely right and they have been used interchangeably in section 7 by the legislature. Okay, then the court agreed with the submission made on behalf of the accused that expression sexual intent in section 7 cannot be confined to any predetermined structure and is a question of fact to be decided in each case. The court, however, rejected the submission that physical contact in section 7 means skin to skin contact, relying on the maxim ut rich res magis valeat quam period. The court observed that any narrow interpretation which would defeat the object of a provision cannot be accepted. If we are attributing narrow interpretations and if it is defeating the object of the law, then it cannot be accepted. Okay, interpreting the expression physical contact to mean skin to skin contact would lead to an absurd interpretation that could not have been the intent of the legislature. Such interpretation would frustrate the very object of the statute and would be very detrimental, as the acts of touching the body of the child with gloves, cloth or condoms would not amount to sexual assault under section 7 even if they are committed with sexual intent. That means even if the accused is using gloves or he's using cloth or he's using any covering like condoms, then in that case this would not amount to sexual assault even after such a disgusting act has taken place. It will not amount to sexual assault, so we cannot do that. The Supreme Court was not of the view. Okay, then the court observed that it is a settled position that penal statutes have to be construed strictly, but it is equally settled that clauses of a statute should be construed with reference to the context and other provisions so as to make a consistent enactment of the whole statute relating to the subject matter. Okay, the court refused to apply the rule of lenity and observed that it is a settled proposition of law that the statutory ambiguity should be invoked as a last resort of interpretation. Where the intention of the legislature is clear, the courts cannot manufacture ambiguity in order to defeat such intention. The court held that there is no ambiguity or obscurity in section 7 so as to invoke the rule of lenity. Okay, understood? Have you understood up till here? Any question, any problem? Understood or not? Where are you people? Now judgment of the okay, Nikhil, thank you. On judgment of Honorable Supreme Court, a 3-judge bench of the Supreme Court consisting of Justice Bela M. Trivedi, Justice U. Lalit and Justice S. Ravindra Bhatt heard the case and disposed of the 5 appeals. The majority judgment was authored by Justice Bela M. Trivedi on behalf of herself and Justice U. Lalit, and Justice S. Ravindra S. Bhatt delivered his concurring opinion separately. Okay. Now 3-judge bench of the Supreme Court consisting of Justice Bela M. Trivedi, Justice U. Lalit and Justice S. Ravindra Bhatt heard the case and disposed of the 5 appeals. The majority judgment was authored by Justice Bela M. Trivedi on behalf of herself and Justice U. Lalit, and Justice Ravindra S. Bhatt delivered his concurring opinion separately. Now, Justice Bela M. Trivedi and Justice U. Lalit gave the following judgment. The most important ingredient for constituting the offence of sexual assault under Section 7 of the POCSO Act is sexual intent and not skin-to-skin contact. Sexual intent is important under Section 7. If there is an intent and if even little act has been done in furtherance of that sexual intent, the offence under Section 7 of the POCSO Act is complete, and no skin-to-skin contact is further required to complete the offence. Secondly, the High Court erred in holding the accused Sateesh guilty for the minor offences under sections 342 and 354 of the IPC and acquitting him for the offence under section 8 of the POCSO Act. The High Court was wrong in holding that there was no offence since there was no direct physical contact, that is skin to skin, with sexual intent. The High Court was wrong in holding that there was no offence since there was no direct physical contact, that is the skin to skin, with sexual intent. So the Supreme Court was trying to rebut the observations of the Bombay High Court and said that skin to skin contact is not necessary. Okay. And the High Court said that the High Court said that it was wrong in holding that there was the High Court was wrong in holding that there was no offence since there was no direct physical contact. Okay, then construing section 7 of the POCSO Act on the basis of the principle of ejusdem generis is wholly misconceived. Such a principle should be applied only as an aid to the construction of the statute and should not be applied where it would defeat the very legislative intent. Okay, ejusdem generis means of same nature, and this is the principle of the interpretation of statutes of the same nature. Construction of the statute and should not be applied where it would defeat the very legislative intent. Where the specific words used in the section exhaust a class, then it has to be construed that the legislative intent was to use the general word beyond the class denoted by the specific words, and such is the case with section 7 of the POCSO Act. The fact that the accused took the victim to his house, lied to the mother of the victim about her whereabouts, etc., having been proved by the prosecution, entitled the court to raise a presumption about the culpable mental state of the accused under section 30 of the POCSO Act. The accused has failed to rebut such presumption, and hence sexual intent under section 7 of the Act stands proved. Also, the act of accused of pressing the breast and removing salwar and using force to press mouth, having been proved, constitutes sexual assault punishable under section 8 of the Act. So that simply means that sexual intent and a little act is enough to constitute and complete the offence under section 7. Skin to skin contact is not necessary. In the case of accused Libnus, the High Court has committed a grave error in holding that acts of holding the hands of the prosecutrix or opened the zip of the pant do not come under the definition of sexual assault. The High Court has committed a blunder, and it said that if the holding the hands of the prosecutrix or opening the zip of the pant, they do not amount to sexual harassment or sexual assault. The court held that such acts constitute sexual assault under section 7, and the fact that the victim was below 12 years of age, the accused is guilty of commission of aggravated sexual assault under section 9M of the Act and is liable to be punished with imprisonment for a term not less than 5 years under section 10 of the POCSO Act. Now, Justice Ravindra S. Bhatt's opinion was a concurring opinion, but he drafted his judgment separately. He, in his concurring judgment, pointed out the need to interpret the statute in the context of the circumstances that resulted in its birth. In his judgment, the Honorable Judge resorted to the mischief rule of interpretation of statutes, which provides that courts have to interpret the law so as to suppress the mischief and advance the remedy. He noted that the judgment given by Bombay High Court tends to continue the mischief that the Parliament wished to avoid. He also noted that in Section 7 of the POCSO Act, the term physical contact is of wider import than the word touching and is not limited to touch. The expression any other act involving physical contact may include direct physical contact by the offender with any other body part of the victim except those mentioned in the first part of Section 7, and other acts such as the use of an object by the offender engaging physical contact with the victim. Even no contact by the offender may come under the purview of the expression any other act. For example, in a case where the victim is coerced to touch oneself. Okay? To determine whether touch or physical contact is made with sexual intent, one has to look at the surrounding circumstances. For instance, the nature of the relationship with the child, the length of the contact, its purposefulness, and whether there was a legitimate non-sexual purpose for the contact, place and conduct of the accused before and after such conduct are all relevant considerations. Courts have to keep in mind that sexual intent is not defined but is dependent on the facts of a case. Now, order by the Supreme Court. The Supreme Court set aside the order passed by the Bombay High Court in the case of accused Satish and restored the order of the Special Court. The accused was convicted for the offence punishable under Section 8 of the POCSO Act and Section 342, 354 and 363 of the IPC. The accused Satish was directed to undergo rigorous imprisonment for 3 years and a fine of rupees 5,000, and in default thereof to undergo simple imprisonment for 1 month for the offence under Section 8 of the POCSO Act. As the accused was sentenced for the major offence under Section 8 of the POCSO Act, no separate sentence was imposed upon him for the other offences under the IPC. Okay, now this was the fate of Satish. This was the fate of Satish, that he was also convicted under the POCSO Act. And what was the fate of the Libnus? The accused Libnus was convicted for the offences under sections 354A11 and 448 of the IPC as and for the offences under sections 8, 12 and 10 read with section 9M of the POCSO Act. The court directed him to undergo rigorous imprisonment for 5 years for the offence under section 10 of the POCSO Act and to pay a fine of rupees 25,000 and in default thereof to suffer simple imprisonment for 6 months. No separate sentence was imposed upon him for the offence or the other offences under the IPC and the POCSO Act. Now, have you understood? And if you have any questions, you are most welcome to ask. No questions? Baat Jazbato Tum has understood. Nikhil has also understood. Okay, then I'm ending the stream. I'm signing off and let's meet tomorrow with another case. Okay. Thank you all.